Good evening, ladies and gentlemen. Welcome to the IDMNC International webinar on Judicial Preview Power on Laws. I am Rivin Kumar Naika, your moderator for today's event. Our speakers for today's event are Mr. Ruchira Pereira and his Assistant Lecturer in Political Science at the Department of Public Policy of the University of Ruhuna. And we also have Mr. Gimha Surya Bandara, who is an attorney at law, tutor in political science, published author, and an activist. Let's welcome them both with a warm heart. Today's webinar will explore the role and powers of the judicial system in a governing state. Our speakers will be explaining them in the major aspects as well as provide specialized understanding on this topic. First up is Mr. Ruchira Pereira, who would be explaining the basic explanation on the institutions of the government, as well as providing a specialized explanation on the judiciary.
Good evening, everyone. So, first of all, I would like to thank you for the opportunity that you have given me to join this discussion as a panel member. So, our main topic today is obviously judicial preview power on laws. So, therefore, I have been firstly given to explain about the main institutions of the government, their functioning, and what are the duties and what are the institutions that are there in the government to conduct the duties. And of course, then I will explain specifically about the duties of a modern judiciary and how the judiciary interacts with the other institutions of the government. So let's firstly, I'll give you a brief introduction about the main three institutions of the government and the duties of those three institutions. Before speaking about it in an institutional perspective, I should mention that these institutions has been structured to function a certain duty. So then the duty comes first before the institution, right? In any sort of government, there will be a legislative action, executive action, and the judiciary, right? It does not need three separate institutions to conduct such powers. Now, as you know, in the days of the monarchical form of government, these three duties has been conducted by the monarch, mostly by the king. It is the king who made the law. It is the king who implemented the law, and it's the king who did the adjudication stuff as well, right? However, with the beginning of the modern period, political thinkers thought that it is better to have three institutions to conduct these three actions of the government. Of course, if you look back at the ancient history, even in the 5th century BC, Aristotle also mentioned that there should be sort of three institutions to conduct the activities of the government. But it became mostly a reality in the modern period. In the modern period, with the collapse of the medieval Holy Roman Empire. So, before looking at the philosophical roots and the philosophical perspective of the institutions of the government, let's look at what are the actions or activities that named as legislative, executive, and judicial. Legislative is making of the law, right? Legislative action is basically making the law, right? Then the executive action is obviously implementation of the law, right? After laws has been made by the legislator, the executive could implement. And then there is a judiciary to adjudicate the law, right? These are the main three actions. But however, if you look at a modern day legislator, there are far more duties than the lawmaking, right? It could inquire into the budget of the political system, and it should control the executive, and the legislator also initiate certain public, the legislator provides approval to the certain public policies as well. But in a modern complexive democracy, legislator do much more duties than the making of the law. But anyway, these are the three duties of the government, and these three types of duties could exist in any sort of government, in any form of government. It does not have to be a democracy at all, because as I mentioned earlier, in the monarchical system as well, these three powers existed. So then why should we need three institutions to conduct these three types of powers? Now, there are various political thinkers, as I mentioned, explained about this concept, so-called separation of powers. The main thinker is Charles Montesquieu, the French philosopher, who were mainly influenced by the Louis dynasty that was there in the 18th century. So Louis dynasty is sort of a dictatorship ruled by the king. So they thought that if the powers are conducted through different three institutions, then there will be more democracy. That's what Montesquieu understood through observation of the English political system, because at that time, in 1688, British Revolution or the Parliamentary Revolution was already happened. So Montesquieu thought that if there is sort of a separation of powers among the duties of the government, it could uphold democracy, right? So, however, if you look at the actual perspective, it is not that easy to separate these three powers of the government. And there is another author known as Blackstone, who wrote about the commentaries on the law of England. And Blackstone says that there should be a balanced equilibrium among the powers of the government. So it should be balanced. Again, he also develops the Montesquieu's idea that there should be three separate institutions, but in a more balancing manner. But of course, if you look at the modern day democracy, mostly the legislature and the executive are interdependent and interrelated between each other. You could not make such kind of a permanent institutional separation among the legislature and the executive, because those two institutions of the government represent the elected representatives. Unlike the judiciary, executive and the legislature, it contains elected representatives. So there should be a sort of a collaboration. There should be a sort of a better synchronize between the legislature and the executive to make the government function in an effective and efficient manner. So today there is a sort of a interpretation done by political scientists. Political scientists in the modern era believe that separation of powers does not mean anything else than the independence of judiciary. So they feel that the executive and the legislature should function in a collaboration, right? There should be sort of a harmony between the legislature and the executive. Otherwise, there will be constitutional deadlocks, right? The best example is what happened in Sri Lanka in 2018. So they believe that while the executive and legislative functioning together, judiciary must be independent, because there are certain kinds of duties that should be conducted by the judiciary. So next, I will look at the next section that I should explain today, and that is the duties of the judiciary and what the judiciary should do. As I mentioned earlier, the main duty of the judiciary is to adjudicate the laws, right? To find out whether there is a breach of law, right? That is the main duty, the adjudication process. Other than that, judiciary has some other duties as well. Judiciary works as the protector of the fundamental rights of the citizens. Now, you know what are fundamental rights. Fundamental rights are the rights which are given by the fundamental law. Now, fundamental law in a country is the constitution. If there are a certain amount of rights which are provided and safeguarded by the fundamental law, it becomes a fundamental right. So unlike the human rights, fundamental rights are unique to the relevant country. So judiciary works as a protector of the fundamental rights. And the judiciary has the power to interpret the constitution, right? So even in countries like Sri Lanka, judiciary is the sole owner of the power to interpret the constitution. That's another duty conducted by the judiciary. And the judiciary should ensure that there are checks and balances among the governing systems, right? Now, checks and balances literally means that an institution should inspect whether other institutions are functioning as a democratic manner. So judiciary should ensure that there are fair checks and balances among the institutions of the government, right? And furthermore, judiciary will also work as a protector the judiciary will also works as a protector of the democracy of the society, right? And the judiciary, in certain cases, could advise the other institutions of the government. With regard to system of Sri Lanka, if there is any sort of situation, the president, if there is any sort of situation as mentioned in the constitution, president could seek the opinion from the judiciary, right? So these are the main duties of the judicial system in any sort of country other than the adjudication. And most importantly, in the democratic world, there is a concept known as the judicial preview and the judicial review, right? Other than all of these duties that I mentioned, other than the adjudication, protection of fundamental rights, ensuring checks and balances, interpretation of the constitution, interpretation of the law, there is another important duty that the judiciary should conduct, and that is judicial preview and judicial review. And obviously, as we go through the discussion, Mr. Gimhan will give you sort of a perfect explanation about these two concepts. So I feel that I have given a certain outline about the main three institutions and the main three functions of the government. So I didn't dig deep to these philosophical roots and the Montesquieu theory and other stuff as well, because in the limited time span that we have given, we had to do the discussion. So, and I also provided certain kind of a introduction to the main duties of the judiciary as well. So then onwards, I think Mr. Gimhan could continue with his explanation about the judicial review power and the preview power.
Thank you, Mr. Ruchira, for your valuable input. Now we have Mr. Gimhan, who would be explaining to you the role of the judiciary in reviewing laws, as well as to explain the differences between the judicial review and preview powers. Before that, please take a minute to answer this poll, which would be reflecting on your understanding on the topics. The first question is, any citizen can challenge a bill drafted by the executive in the judiciary, true or false? And secondly, it is possible to challenge the eligibility of a law once it is passed in the parliament, true or false? Now let's welcome Mr. Gimhan onto the spotlight.
Thank you, Ravi. And thank you for IDM Nations Campus for having this important panel discussion, this webinar. It's actually quite reasonably important knowledge for every citizen to have. Like, it's not something that we talk about quite often, as we should be, speaking about, right? Now, you can see, even when you look at the poll numbers right now, which was just posted, it's clearly a split call, right? Now, we'll address these questions in a bit, but you can see that it's a divided opinion when it comes to the citizens, that we do not talk enough about this part when it comes to the judiciary's role, and about like reviewing laws passed by the parliament, right? So as Mr. Ruchira Perera first introduced, as he gave you an introduction, I think it's clear that what each institution, that every government has 3 institutions, executive, legislature, and judiciary. And it's quite clear that what each institution does. And Mr. Ruchirapura gave like a very clear explanation on that, right? So now let's see what is the role of the judiciary specifically, right? As Raveen asked me that question, what is the role of the judiciary? Now, as Mr. Ruchirapura also mentioned earlier, that there are duties to adjudicate the laws, right? The laws are made by the executive and the judiciary together, and then the executive is there to implement those laws, and the judiciary is there to adjudicate, which means, like in simple words, you have the executive, which is the president and the parliament, deciding what the laws should be. And then the parliament gives their approval, 225 members in the parliament. They take a small vote. As long as the majority in the parliament are okay with that, that provides the approval to the law, right? And then it becomes a law, okay? So that law is implemented by the executive again. So the judiciary is there to punish whoever breaks this law, right? Like someone has to keep these laws and the people accountable, right? Otherwise, people wouldn't follow if no one gets the punishment for breaking the laws, right? The judiciary's main duty is to punish whoever breaks these laws. Like, you know, when there are cases of these laws not being followed, judiciary is there to run basically a court case, court investigation to see whether whoever the person is accused of breaking the law, whether the person is guilty of breaking the law. If the person is guilty, then the court gives them a punishment, right? So judiciary has a lot of duties. Judiciary has a lot of things to do. This is the most well-known one. Like, you know, you go to a courthouse, they are to like hear court cases and give punishments to people whoever have you know, broken laws. Like, it's legal matters, solving cases. But solving cases isn't the only thing that courthouses normally do, right? There are plenty of other things they do. Like one for once, the court is there, the judiciary is there to hear fundamental rights cases. We earlier did our first webinar on our webinar series was about fundamental rights, right? So the judiciary has the power to protect the fundamental rights of the citizens. Then the judiciary also has the consultation power, right? The judiciary can, the highest courthouse, Supreme Court, can consult lower courthouses, or like they can consult the government regarding legal matters. They also have the power to hear appeals coming from lower courthouses, the Supreme Court of the country. They have the power to hear petitions against elections, right? So a presidential election, if you want to challenge the legitimacy of a presidential election, you go to Supreme Court. If you want to challenge the legitimacy of a parliamentary election, you go to the Court of Appeal, right? They have the power to hear petitions on violations of parliamentary privileges. They have the power to get involved in certain matters, such as like an impeachment against the president, right? In Sri Lanka, if you want to impeach the president, that process doesn't only concern the parliament, right? It comes to the judiciary, Supreme Court also at one point. So the judiciary has a lot of roles. One of the roles that the judiciary has is implementing this power of judicial revision, right? Which means when the executive and the legislature, when they make laws in a collaboration, right? So executive decides what the laws are and the legislature approves those laws. So basically, president, prime minister, and the cabinet are there to decide what should be the law, and then they put it to the parliament and the parliament agrees, then it's a law, right? Now, other than the fact that the judiciary is there to adjudicate whoever breaks the law, the judiciary also has a part to revise these matters, right? Now, I assume all of you know that the country has something called the constitution, right? The constitution. So you have a constitution, and the governance in the country should be going according to the constitution. No one can violate the constitution, right? So what happens when the parliament approves a law which is sent to them by the executive, which violates the constitution? For example, there is a particular law the parliament is about to pass, and that if that law comes to effect, say that clashes with one of the fundamental rights that is given to you by the constitution, what do you have to do then? Who has to stop this? It's the judiciary. So the judicial review, or preview for that matter, like judicial's revision power, that comes into play in such situations. Judiciary is there to stop the parliament from passing such a law, right? So basically to interfere and stop the executive and the legislature from making a mistake and passing a law that is unconstitutional, right? So judiciary can get involved and be like, wait, that law is a violation of the constitution, so you can't pass that. Okay, so basically, according to the principles of separation of powers, as Mr. Richard Pera explained a few minutes ago, these institutions are separated as 3 institutions so that they can check each other's powers and keep a balance of the governmental power. This is called checks and balances, right? This is one of the ways of putting effective checks and balances is the judiciary getting involved. If the executive and the legislature, they are together passing a law which is against the constitution, unconstitutional, right? So the process is that the executive, right? This is the process of a law being born. Like, you know that laws exist. You know that laws exist. You follow laws, but perhaps you never did the research to see how laws are made, right? This is the process of making a law. So first, the cabinet of the country, which is the executive, right? The president, prime minister, and the cabinet ministers, they decide together, they decide what should be the law. They decide and they write it down, right? So basically, when they're deciding initially, say one minister writes it down, the suggestion, and then they put it to the cabinet and they decide that, and that is called a cabinet paper. Must have heard the term cabinet paper, right? So they mutually agree to proceed with that. They make a team effort, right? The president, prime minister, and the ministers, they together, they decide to proceed with the law, and they write down that law on a paper. They draft that law, and that is called a bill, a drafted bill, right? In Sinhala, you call that panat ketumpatak, right? When you're drafting, it is called ketumpatkiri. So that is called a bill, right? And that's drafted. And that drafted bill is sent to the parliament. And in the parliament, they take a vote, right? The members of the parliament, 225, they take a vote. And as long as the majority says yes to that bill becomes an act. Panata in Sinhala, right? So then from the next day onward, it's an act, which means it is a law, right? So a law basically exists in different, in different stages. This is first, it is called a cabinet paper when they are just, discussing that in the cabinet. When they draft it and when it comes out of the executive branch, it is called a bill, a drafted bill, right? When it enters the parliament. And if the parliament provides the approval by giving a majority approval, it becomes an act. So act is the law, right? So if anyone violates that act, if anyone violates that law, the person will be punished in a courthouse under a certain act, under violating a certain section of that act. That's basically how the lawmaking process works, right? But the contradiction comes, what if the executive drafts a bill, and that particular law that they are going to get approved from the parliament is contradictory with the constitution, which means it's going to be an unconstitutional law, right? That's when the judiciary makes their intervention to stop the parliament from passing such a bill, right? Now, in the poll that a question was asked, right? Can we see the poll numbers again? If the admin team can show the poll numbers once more. So a question was asked, can the judiciary, right? Thank you. So second question that was asked, it is possible to challenge the eligibility of a law once it is passed in the parliament, true or false? So basically 58% have said false, 42% have said true. This is actually, first of all, it depends on the country, right? The answer to this question depends on the country. If you take Sri Lanka, it is not possible, right? In some countries, it is possible. This is when the technical term of review and preview comes into play, right? Some countries have judicial review power. Some countries have judicial preview power. Now, if you use the Sinhala words, it's called Adhikarana Purva Nirikshana Balaya, Adhikarana Pratinirikshana Balaya. Preview power and review power. So what's the difference here? I think the words are self-explanatory itself. When you say preview, early, pre, or review, that's looking back. So in a country that has judicial review power without the P, right? Review power. The judiciary is allowed to review laws passed in the parliament, right? So the parliament has passed a certain law. That means the executive has decided, parliament has given approval, it has become an act, it has become a law. And the judiciary says the law you just passed is against the constitution, and judiciary is going to use their power to revoke that, right? Certain countries have this provision in their governmental structures, right? USA has this system on presidential orders, right? You know, in USA, the president can give executive orders. That means without the legislature's approval, they can give an order, and the judiciary can revoke those if they are unconstitutional. If you remember in 2016 or 2017, in USA, President Donald Trump, he gave an executive order banning access to several people coming from several countries. Iraq, Iran, Somalia, Syria, and all those, right? So then there was a question about whether this law actually violates the constitutional principle of equality, right? Because particularly though that ban was put on Muslim majority countries. So although the Trump administration said this is not necessarily a race-based law, but it was banning access coming from for people who coming from certain Muslim majority countries. So it was a question about equal protection given to every community under the US Constitution was being questioned with an executive order like this. So the US Supreme Court used the judicial review power to stop that executive order from being in effect, right, for violating the Constitution. In Sri Lanka also we had this. Now I believe Mr. Ruchira Perera will explain this further in his next session, right? Sri Lanka has had 3 constitutions. Salisbury Constitution from 1947 to 1972, First Republican from 1972 to 78, and currently we live under the Second Republican Constitution since 1978. So the very first constitution we had under 1947, since Salisbury, during that constitution, we had judicial review power. That means a certain law that is passed in the parliament can be revoked by the judiciary. But this, of course, creates a bit of a question, because the judiciary, the judges, they are not public representatives. They are not voted in by people, but the members in the parliament are voted in. President, Prime Minister, they are voted in by people. So people appointed executive and the legislature making a certain law, and a non-appointed body like the judiciary having the power to revoke a law sort of raises a question about the democratic principles, right? So, and also it's sort of a hit on the legislature's reputation, right? After passing a law, the judiciary being able to revoke that. So because of that, most of the countries use a less aggressive method, which is the judicial preview power. P comes into play, right? P, preview power. That means that you can revoke that when it's a bill, not when it is a law, right? Which means that you know that initially it's a cabinet paper when the cabinet is discussing that, and then it becomes a bill, and the bill comes to the parliament, and the parliament gives approval, and then it becomes an act, becomes a law, right? So if the judiciary wants to prevent this law, they have to prevent it while it is in the bill stage, right? While it is in the bill stage. So when a certain bill is put into the parliament, before the parliament takes that into debate and give the approval, the judiciary can stop that from being passed, right? This is called judicial preview power. Judiciary gets involved before it is passed, okay? So now that raises the question, how would you know what is going to be the law before it becomes a law, right? Do you have to attend parliamentary sessions every day? Do you have to go read the documents in the parliament administration office every day to see, like, you know, what bills they are going to pass, right? That's not a problem, because as far the lawmaking process goes, every bill that is about to be discussed in the parliament, about to be given approval in the parliament, has to be published in the government gazette, right? The government gazette, which is basically the notice board for the government, right? Those are the notices government wants to give people. So it is published in the gazette, right? So basically, the other poll question that I asked, if we could have the poll numbers once more, right? The other question that I asked, is it possible for any citizen, right? The first question, any citizen can challenge a bill drafted by the executive in the judiciary, right? So 67% have got the answer right. Yes, any citizen can challenge, right? So any citizen in Sri Lanka can read the newspaper and the gazette, right? And see what bills that they are going to pass in the parliament, and then draft a petition to the Supreme Court to use the judicial preview power and stop this from happening, right? Ideally, this can be done by anyone in the parliament, any political activist, right? Anyone. So basically any citizen, any of you all can, as long as you all feel like it is a violation to the constitution and the government is not supposed to pass this particular law, right? So that is how judicial preview power works. Okay. So when it comes to judicial preview power, also there were certain changes that were made. Now, in the 1947 Salisbury Constitution, we followed judicial review power. That means that we had judicial review power. That means the judiciary could revoke laws which were even passed in the parliament, which have already become acts, right? But in 1972, that was changed, and they changed that to judicial preview power. You had to challenge that while it is in the bill stage. But of course, they had a separate courthouse for that called Constitutional Court, and there were some issues about the legitimacy and the authority of that courthouse, because the parliament at that time was known as the National State Assembly. That was too powerful, right? And then in the 1978 Constitution, they continued with the judicial preview power, and that power to seek judicial preview cases is given to the Supreme Court of Sri Lanka. That was also changed under the 19th Amendment, because the rule says that the executive has to put that in the government gazette 7 days prior before they take that into the vote in the parliament. I think the 19th Amendment increased that to 14 days. So you have 2 weeks to challenge that, read that and challenge that in the courthouses. I think under the 20th Amendment, it was revoked back to 7 days. Those things, I think Mr. Ruchirapera will give a better explanation, better understanding, right? So I think we can go back to Mr. Ruchirapera for his last session, and after that we'll answer the questions in the Q&A session.
Thank you, Mr. Gimhan, for your important insights. Next, I'd like to invite Mr. Ruchirapera back into the spotlight to talk about the history of judicial review and preview power in Sri Lanka, as well as to talk about its current status in Sri Lanka following 1978. Before that, we also have another poll which would also reflect on your current understanding of the topic. The two questions are: judiciary can decline the laws formulated in the parliament, true or false? And we have judicial review does not exist under the 1978 Constitution, true or false? So let's invite Mr. Ruchirapera back into the spotlight.
Yeah, okay. So Mr. Gimhan delivered a perfect explanation about the judicial preview power and the judicial review power, and what are the differences between these two concepts. So now my duty is to actually explain you about the judicial review and preview with relevant to the Constitution of Sri Lanka. Yeah, can you decline this poll? Yeah, okay, thank you. So firstly, now as Mr. Gimhan mentioned, we have to discuss about three constitutions: the Salisbury Constitution of 1947, the First Republican Constitution of 1972, and the Second Republican Constitution of 1978. So firstly, we'll take a look at the Salisbury Constitution. As you know, Salisbury Constitution is a granted constitution. It was granted by the British and is not a homegrown constitution. As you know, it encapsulates some of the main features of the Westminster form of government, which is obviously the original system that existing in Britain from 1688 onwards. So, considering the judicial review power of under the Salisbury Constitution, before that we need to identify few concepts. Now, under the Westminster system of government, there are two concepts that comes to our mind when we discuss about the parliament or the legislature. Those are the parliamentary sovereignty and legislative supremacy. So I have seen in Sri Lanka, some of the political critics and some of the political science teachers misinterpret these two concepts, right? But however, there is a considerable difference between these two concepts. Now, as you know, in the British Revolution, which took place in 1688, most of the powers of the monarch shifted to the parliament. And that is why John Locke actually wrote the two treatises on civil government to justify the parliamentary revolution. He said that the sovereignty of the people will be exercised through an assembly of men. Assembly of men means, of course, the legislature. So then comes this concept of parliamentary sovereignty. Author Jean-Louis de Lolme said that, once he said that, the only thing that the parliament couldn't do is make a man a woman and woman a man. Now, he mentioned this in 1838. At that time, it might not be possible, but considering today, it can be possible. But whatever, he wants to illustrate the absolute power that the parliament had. And then famous author A.B. Dicey, he said that, Dicey once quoted that there should not be any body or any person recognized by the law of England which could set aside or override the legislative powers of the parliament, right? So there are two interesting terms in here: set aside or override. Set aside means there should not be any institution which can compete with the powers of the parliament, and there should not be any institution which can surpasses the powers of the parliament. And furthermore, Dicey says that the courts are required to give approval for the most recent expression of the parliament. Now, in that nature, you could think that there is sort of a subordination of the judicial institutions to the parliament, because all of these things comes under the concept of parliamentary sovereignty. So therefore, if it is a constitution which encapsulates the concept of the parliamentary sovereignty, as mentioned in the classical Westminster form, the judicial, not only the judicial review, but also judicial preview might not be possible. But however, if you look at the situation today, today we are discussing about some sort of a linear concept than the parliamentary sovereignty, which is known as the legislative supremacy, right? So legislative supremacy is all about supremacy in lawmaking, the supreme authority in lawmaking, right? So under the concept of legislative supremacy, judicial review power, which means reviewing the law after it has been duly approved by the parliament, that should not be possible. But under legislative supremacy, the judicial preview power can be possible, right? So there are two different terms. Now, as we know, the Salisbury Constitution of Sri Lanka was granted by the British. Mainly, it was framed by Lord Salisbury and Sir Ivor Jennings. Although it was structured into the framework of the Westminster, the Parliament of Salisbury had certain limitations, right? Out of that, one of the limitations are the judicial review, which means even a law has been duly approved by the Salisbury Parliament, the court can review the law and decline it, right? The courts has the power to do so. However, so as I explained, under the sole body system, the judicial review power is also possible. But if we move on, if we consider about the first Republican Constitution of Sri Lanka, now Mr. Gimhan also mentioned briefly about it. First Republican Constitution is a homegrown constitution. We call it the autochthonous constitution, which means it's self-sustaining. Now the first Republican Constitution has been formulated through a process of the constitutional revolution. As you know, after the general elections of 1970, the political alliance, so-called Samagi Peramuna, got a 2/3 majority, and then they promised to deliver a new constitution to Sri Lanka while breaking the regal bindings with the Britain. So they surpasses the old parliament, and they had their constitutional assembly under the auditorium of Royal College, and they formulate this first Republican Constitution to make Sri Lanka a free, sovereign, independent state. So under the first Republican Constitution, as Mr. Gimhan mentioned, National State Assembly become the supreme institution of state power, where it also sort of encapsulates the legislature and the executive and judicial power in the one institution. It has been structured into the parliamentary system of government. Under this constitution, judicial review power is not possible whatsoever. But however, there was an institution that has been structured by this constitution known as the Constitutional Court, which is mentioned in the section 54, subsection 1 of the Constitution. It has certain powers regarding the judicial preview. Right, I'm not going to go through the procedure of the section 54, but if you go through it, you could realize how it can be previewed. Now, preview means I think you can remember. Preview means you must do it before the parliament or the legislature duly approve the law at the bill stage, right? When it is at the bill stage, you can review, and there are several ways to do it, as it is mentioned in the section 54, subsection 1 of the first Republican Constitution. But however, this constitutional court is somewhat separated from the main judicial structure. So that is why this became sort of a controversial discussion among the political scientists regarding the validity and the functioning and how it affects the democracy of the country, right? So this was the situation of the first Republican Constitution of Sri Lanka. It had an institution known as the Constitutional Court, which had the judicial review power, not review power, but review power. Again, there are certain sort of opposing arguments as well regarding the Constitutional Court, whether it facilitates for the democratic functioning of the government or not. Now then, we can look at the current constitution and what actually matters today. If you look at the second Republican Constitution of Sri Lanka, the basic, if I illustrate briefly about the basic framework, this has been structured into a semi-presidential form of government, right? So the main framework of our constitution has been uplifted from the fifth Republican Constitution of France, formulated in 1958. And that is why the current constitution of Sri Lanka is known as the Goldie System of Asia, which was written by a famous author, A.J. Wilson. A. Jayaratnam Wilson said that this is the Goldie System of Asia because this has been structured according to the Fifth Republican Constitution of France. So it's a semi-presidential system. Therefore, judicial review power under this system is not included. Although this does not have a sort of a superior parliament as a national state assembly, therefore this obviously this does not contain the judicial review power, but it also has judicial preview power. Now the current parliament has the supremacy in lawmaking, which is the legislative supremacy, and And that is why the judicial review is not possible, but preview is possible. Now, if you look at the procedure of the parliament, firstly, you should include into the paper of agenda, and then the public gazette will be done, and then there will be the first reading, second reading, committee stage, report stage, third reading, and then only after the third reading there will be a vote in the parliament on a necessary manner. If it is a constitutional bill, of course, you need to get the 2/3, or in certain given situations you have to go to a referendum. Then within this process, which means before parliament duly approve it as a law, one could challenge a bill, right? And then so now I would like to come back to the polls that are given. If you could pop it up in the screen. Judicial review does not exist. Yes, so you have okay, thank you. The courts could decline the laws which are formulated in the parliament. It is, when considering the Solberg, it's true, but if you consider the second Republican Constitution, it's not true. So and I was explaining about the process in the parliament. So you have to challenge the law before it duly approved by the parliament. After the speaker enacts his signature in a normal situation, or if the act goes through, if the bill goes to a referendum, then after the president enacts his signature, no one could challenge that particular law, because then it is duly approved by the parliament, right? So if it goes through the normal procedure, the speaker have to enact the signature. If it goes to a referendum, then the president had to enact his signature. So now the other important factor in here is that what we can do with the laws or proposed bills which are inconsistent with the constitution. In Sinhalese we call it Aandukrama Vyavasthawata Ananukula Pana. Now the current parliament also could approve laws which are inconsistent to the constitution, inconsistent with the constitution, right? Now just think, if there is a certain a bill which is proposed to the parliament and which has been challenged under the challenge utilizing the power of a judicial preview, Supreme Court could determine that this law is inconsistent with the constitution. But however, Supreme Court could not decline the law. Even it is inconsistent with the constitution, Supreme Court will give sort of a recommendation what to do, which means the Supreme Court will say that this law, this proposed bill is inconsistent with the constitution, and you should go through the special majority, and you should obtain the special majority of the parliament, including those who are not present, which means that even there are 180 members present in that particular day, you must obtain 150. That is what is meant by including those who are not present. So Supreme Court might recommend to approve that bill with 2/3 majority if it is inconsistent with the constitution, or in certain cases if it is conflicting with certain sections of the constitution, like number 1, 2, 3, and of course the 32 subsection 2 and 62 30 subsection 2 and 62 subsection 2. Supreme Court could determine that you should go for a referendum as well, other than the 2/3 majority of the parliament. So what I want to illustrate in here is that even if a proposed bill is inconsistent with the constitution, Supreme Court cannot nullify it. Supreme Court cannot decline the law. Supreme Court can only give certain recommendations to approve the law. So so then there will be a sort of a question whether any sort of institution in Sri Lanka subordinates to another, right? Now, as you know, there are 3 institutions. The most criticism in the Sri Lankan system is that the executive is already superior, and there are fair amount of discussion about it. Now, when we compare the judiciary and the parliament. Obviously, it's the parliament, according to section 4 of the constitution, which has the power to establish the court structure as well, right? If you look at the section 4 of the constitution, now I'll give you a sort of example regarding the practical situation in Sri Lanka when there was a sort of a conflict between the parliament and the judiciary in Sri Lanka. If you could remember the impeachment procedure which was done against Mrs. Shirani Bandaranayake in 2013, when there was a sort of a trial held in the parliament according to section 107 subsection 2 of the constitution to impeach the CJ of the Supreme Court. The Supreme Court had given a certiorari writ to halt the judicial procedure in the parliament. So then there was a discussion among the lawyers that whether this certiorari, whether it is possible or not. But I could remember there was the former CJ, Mr. Saratnanda Silva. He quoted the section 4 of the constitution and said that it is the parliament which established the judicial structure, and therefore the judiciary cannot make such kind of writ orders to the parliament, because the parliament becomes, in that case, the superior, and because it contains the elected representatives. So therefore, in the second Republican Constitution of 1972, yes, you have the judicial preview power, but then again, the judicial can recommend the parliament approve it in this sort of manner, approve it with a 2/3 majority or 2/3 majority plus referendum, and do it according to the law. Other than that, the judiciary cannot decline the laws. After it is duly approved by the parliament and after the speaker or the president enacts his signature in a relevant situation, there onwards, there is no authority in the island which could challenge the law that has been duly approved in the parliament. So this is my explanation about the judicial review power in Sri Lanka relevant to the Salisbury, first Republican and the second Republican. So in the Salisbury, the judicial review power is possible. But if you look at the first Republican and the second Republican constitutions, the legislators of the first Republican and the second Republican constitutions contain the concept of legislative supremacy, which is the supremacy of lawmaking. And therefore, the judicial review power is not possible in both of these constitutions, but the judicial preview power is possible in with regard to the National State Assembly of the first Republican Constitution as well as the Parliament of the second Republican Constitution. So this is my explanation about the judicial review power and the preview power with relevant to the constitutions of Sri Lanka. Thank you.
Thank you, Mr. Ruchira, for your valuable views. Now we move on to the Q&A session for today's event. Since we would only be allowing 4 questions, please get your questions coming in fast to get them answered. We already have one question online. It goes, I feel that the judiciary also functions in favor of the state than being a neutral service. Is there any mechanism to rectify it? I think Mr. Ruchira can answer that question.
Yeah, of course, the mechanism is strengthening the independence of judiciary, right? That is the only way that we could make it neutral. So that is why in Sri Lanka, there are several amendments that have been introduced to make the judiciary independent. Now, if you could remember in the Salisbury Constitution of Sri Lanka, there is the Independent Judicial Service Commission. And if you look at the current Constitution of Sri Lanka, the 17th Amendment introduced the Constitutional Council, and then again it was pulled back in the 18th Amendment, and they delivered the Parliamentary Council, which cannot actually make the systems independent. And then again, the Constitutional Council came into existence in the 19th Amendment, and again in the 20th Amendment it was pulled back. So those are the measures that are taken in Sri Lanka to ensure the independence of judiciary. But if you look at some other countries in the world now, especially if you look at the USA, in America, judiciary is extremely powerful, right? Because judiciary works as a protector of the Constitution and the protector of the federal system, right? So in America, judicial review is even possible as well, right? If there is a conflict between the federal government, between the central government and a state in USA, it's a judiciary who will be the mediator, as well as who will have the authority to resolve such disputes and make recommendations. So strengthening the judicial structure, making it more independent, accepting the independence of the judiciary, through those measures, we could make the judiciary more neutral. And of course, the public awareness and education about these sort of stuff is also required. Otherwise, if the public does not understand the necessity of the independence of the judiciary, it's not going to work, right?
Thank you, Mr. Ruchira. There's also another question for you. Could you explain the differences made in the 19th Amendment?
Yeah, of course. 19th Amendment happened in 15th of March 2015. So I have a certain criticism about it as well, because 19th Amendment has been approved by the Parliament in sort of a hesitation, right? It was approved, if I could remember, 11:30 night. So there is a concept that goes in favor with the bicameralism. Now, bicameralism is where there are two houses in the legislature. So under bicameralism, the second house could check upon the legislation done in the first house, done by the first house. So it is there to prevent legislation done with a hesitation. But however, this amendment happened instantly, which created sort of a different two types of power blocks, kind of a unequal cohabitation between the Prime Minister and the President. But looking at the independence of the judiciary, yes, the Constitutional Council was established, and the Constitutional Council will give approval for the President's appointments to the Supreme Court as well as the Appeal Court. So when President makes his appointment, when President appoints the CJ of the Supreme Court and other judges, when President appoints the President, judge of the Appeal Court and other judges, all of those names must be approved by the Constitutional Council. So that is the mechanism made under the 19th Amendment to strengthen the independence of judiciary.
Thank you, Mr. Ruchira. We have our two questions for Mr. Gimhan. The first one is, does Judicial Review Power protect minority communities?
Right. That's actually a good question. I mean, someone who normally studies history or political science would know this, right? One of the main reasons that we introduced judicial review power under the 1947 Salisbury Constitution was to protect minority communities. Right now, if we go back to the roots of this, the issues that we are having in Sri Lanka with regard to, like, the disparity between the communities, like the disharmony between communities, right? I mean, it's no secret that in Sri Lanka, the Sinhalese, Tamils, and the Muslims aren't getting along that well. At least now it's somewhat better, right? But we have a very unfortunate, sad memories, sad phases that we've passed with, like, communities not necessarily getting along with each other. Like, we even fought a 30-year-long war because of these issues. So when we look at the minority communities in Sri Lanka, so this conflict was initially started during the British colonial era, right? The British rulers in Sri Lanka, they particularly used the divide and conquer theory. They purposely had certain policies to create conflicts among the communities in Sri Lanka, Sinhala, Tamil, Muslim, and Burgher, right? So by the time we got independence, that these issues between the Sinhalese and the minority communities were so severe that the minorities feared having a Sinhala majority parliament, Sinhala majority government under the leadership of a Sinhala prime minister. So they raised their concern to the British rulers, and then they said that we need some protection in our constitution. Now, the Salisbury Constitution did not have fundamental rights. We discussed this in our first webinar as well. Instead, they had these minority protection clauses. So minority protection means that there were certain clauses in the constitution to protect the minorities. And that included judicial review power, right? So judicial review power was there. It was the more aggressive option, review power. That means that even when a law is passed, the judiciary could intervene. So the main reason that it was introduced in the Salisbury Constitution was to protect the minorities. Yes. So most of the times, the laws that are challenged in terms of constitution, most of the laws that are challenged are regarding these the protection of communities, right? So most of the laws that sort of pose a threat on communities, it could be like ethnic minorities, could be sexual minorities, gender minorities, right? So it could be anything. So any minority, but like, you know, when a certain law is passed to sort of like, you know, harm these minorities, you can use the judicial review power to challenge such laws. So yes, it does protect minority protection. It does provide minority protection, and that was one of the reasons that this was introduced to Sri Lanka under the Salisbury Constitution in the first place.
Thank you, Mr. Gimhan. So the last question in the Q&A session is again for Mr. Ruchira. It goes, what are the advantages of the 19th Amendment than the other amendment?
Yes, now we have been mainly discussing about this amendment for now about 8 years. Yes, I could point out the right of information included into the Constitution, which is good. And then the establishment of the Constitutional Council, and then reducing the terms of the president to contest as 2 terms, and the duration of the term of the president and the parliament for 5 years from 6 years. So those are positive, progressive amendments. But however, as I mentioned, this creates sort of an imbalanced cohabitation. Now, even when I was a university student, I did an assignment in 2015. I think that was in my first year, how 19th Amendment facilitated for democracy. But all of us got to know the loopholes of the 19th Amendment in that constitutional turmoil which took place in Sri Lanka in October 2018, right, where there was a huge constitutional turmoil. And it created sort of a vacuum between the president and the prime minister. Hence, mostly terrorist organizations got the opportunity there onwards to do such sort of devastating attacks. So yes, there are certain positivities, there are certain advantages of the 19th Amendment, but however, the executive was sort of imbalanced because the power. Now, if you look at the French system, which is mostly identical to them, the president will look at foreign affairs, the prime minister will look at local affairs, and therefore there is a certain clear split of powers, right? It is not sort of a mixed bag, but in Sri Lankan system under the 19th Amendment, it's sort of a mixed bag. So president and the prime minister always there is an always sort of a conflict, right? So yes, those are the advantages, and there are major disadvantages, loopholes as well in the 19th Amendment, as I see. Okay. Right.
Thank you, Mr. Ruchira, for your comprehensive answer. And since there are no more questions, I believe we can come to an end to today's event. Thank you to our speakers, Mr. Ruchira Pera and Mr. Gimhan Suryabandara, for your valuable input today. We are also very thankful for our participants for joining us today. We hope you enjoyed it. Have a good night.